Hello guys, and welcome to another episode of my lecture. On today's episode, we will be discussing admission by conduct. Whether or not admission by conduct would be a valid admission. In my first lecture on admission, I discussed the nature of admission and the definition of admission. After that, I discussed the types of admission. But in this particular lecture, I will be discussing about admission by conduct. Let's go straight to my notes. Now, to better understand admission by conduct, we need to interrogate the cases. And in the case of AKINBIYI versus ANIKE, the plaintiff sued defendant to recover money allegedly paid by him on behalf of the defendant. The defendant counterclaimed, that is, countersued against the plaintiff for detention of her goods, which was wrongly detained by the plaintiff. In support of a claim, the defendant tendered in evidence a list of goods which also contained their value. The list was admitted in evidence by the trial magistrate without objection by the plaintiff, who did not cross-examine the defendant as to the accuracy of the list. The court held that failure to cross-examine her as to the accuracy of the list was admission that it was correct. In this case, it was held that it would have been different if the plaintiff had tendered a list materially different from that produced by the plaintiff. Also, when we look at the case of Moriarty versus London Chatham and Dover Railway, the plaintiff had procured the services of a witness to perjure, that's lie on oath, in support of his case, which was a claim for damage on account of injuries sustained in a railway accident. It was clearly held by the court that there was a clear admission by conduct that his claim was false or weak, because no one procures a person to lie on oath if he or she has a good case. Now, this exactly is what admission by conduct is talking about. When by your conduct you must have admitted to a particular fact relevant to the fact in issue. Do you understand? When we look at the first case, which is the case of AKINBIYI versus ANIKE, you would see what is the fact in issue. I told you that there are three elements that you should look at when you are talking about admissions. Number one, what is the fact in issue? The fact in issue there was a detention of goods. Do you understand? Now, don't forget that there was a counterclaim and all that, but that's not relevant. In that particular case, what was the issue? Detention of goods. Mr. A is saying that Mr. B has detained his goods. Now, what are the elements to prove when you are saying that somebody has detained your goods? What you are supposed to look at basically is what are the goods that were being detained. Now, in this case, what did the plaintiff do? The person who is saying that his good has been detained, what did he do? He carried the list and he tendered the list to the court that, my lord, look at the list that has been detained. What did the defendant do? Nothing. The defendant let him admit that particular list into evidence. Okay, after that, the defendant did not still cross-examine the witness based on the list. Okay, after that, the defendant did not admit a list that is contrary to that particular list that has been tendered into evidence. What does that leave the court to infer from the circumstance? That the defendant has admitted that the list of goods that has been tendered by the plaintiff are the list of things that, were held down by the defendant, because the claim here, which is the fact in issue, is the detention of the goods. The plaintiff was trying to illustrate to the court that these are the goods, the definite amount of goods that were being detained, and there was no objection by the defendant, which then by implication means that the defendant has admitted, although not expressly, but by his conduct, that yes, those are the goods that were detained. Do you understand that? Because imagine that it was me, and then I don't have anything related to that case. I don't even know what the person is saying, and the person is admitting list. I will object, my lord. I don't know the list that this person is admitting. I mean, do you understand? The fact that I kept quiet meant definitely that by my conduct that I admit that yes, I know what the person is talking about. Do you understand? And then in the second case, the Moriatis case, which is a very important locus classical, you should make sure that you always keep it in your head. Both cases are very, very important. AKINBIYI and ANIKE, and also Moriarty versus London Chatham. Very, very important. In that case, the person went to bring an expert witness to perjure himself. Perjury under criminal law is when somebody lies under oath. Now, the court said that, well, if you had a good case, you don't need anybody to lie for you, because your case, if you are able to prove it, would win. But in this case, the fact that you felt the need to bring somebody to come and lie means that your case is not solid, which means by your conduct you are showing the court that your case is not solid. Do you understand that? And that's how admission by conduct is. And also, as lawyers, outside the confines of exam, as lawyers, it is very, very important that when things happens, you are very, very careful as to things that you keep quiet to. They usually say, oh, keep quiet to this, keep quiet to that, and all that. But then you have to be careful as things you keep quiet to. That's not to say that everything that comes your way, you have to be objecting. Oh, no. That's not what I'm saying. What I'm saying is, you have to be smart enough and all that to be able to look at specific things. Are these under the things I'm supposed to keep quiet? Are these under the things I'm supposed to speak out? Where it's something that would affect your own position on a particular subject matter, you should speak out to that. Do you understand? And that's the same position of the law when it comes to this. When you look at the first case, you will see that because the person kept quiet, the whole position of that person was just basically scattered and all that, and that's what I'm talking about. In my next lecture, I'll be talking about silence, whether or not silence amounts to admission. Some people will say, but we just dealt with conduct. What's the difference between when your conduct is quiet and all that? Don't worry, we will discuss it very well in my next lecture. I'll see you in my next lecture.